Good morning, everyone. This is Michael from NICO's Chinese Health Coalition. I believe it is 10 o'clock, so we will go ahead and get started right now. Thank you all so much for joining on this Saturday afternoon. This is a part of a series of webinars that NICO's provides throughout the year on problem gambling. Let me do real quick. If you could let me know in the chat box if the audio is coming through okay. It looks like from all the indicators on my panel that it looks fine. But if you aren't able to hear me, as you can tell, I'm a little bit under the weather. If you have a difficult time hearing me, or if you need me to be louder, softer, etc., please let me know. And those who have just joined, we have just started. Thanks, Malcolm. Again, if at any time, if there are audio issues, please go ahead and let me know. Great. So a little bit about the organization that is hosting the webinar. Again, my name is Michael Liao. I'm the Director of Programs from NICO's Chinese Health Coalition. We're a nonprofit in San Francisco's Chinatown, and our mission is to enhance the health and the well-being of San Francisco's Chinese community. And problem gambling is one of our major cornerstone projects that we've been involved in since the late 90s. Some of the goals and objectives for today. The purpose of the webinar is to share information that NICO's has gathered through various different methods. We've conducted interviews, key informant interviews with experts in the field of finance and legal assistance for problem gamblers. We've also conducted literature reviews, and we'll be presenting the information that we've collated today. The information that we present is not intended to be legal advice, nor should it be a substitute for any actual consultation with a licensed attorney or financial planner. The information will be, as you can see in all of the slides, the sources where we've obtained the information will be listed so that you can know where that information is coming from. And the PowerPoint slide itself, as well as with other handouts, will be made available after the webinar. Some of the materials are actually already available during the webinar. You might see there is a section called Materials in your go-to training panel, and there you can download all three Word documents that I have uploaded that could be additional resources for you. A few tips on webinar etiquette. I did want to remind everyone that throughout this webinar, all your microphones will be muted to ensure that everyone has a noise-free learning environment. If you do have a need to interact with our presenters, and we'll have two presenters on today, including myself, please go ahead and use the raise hand or type in a question or comment in the chat box feature, and I'll make sure to address it as it comes up. Throughout the webinar, I'll be using some interactive features too, like polls, and asking you to respond via the chat box. So if you are able to be close to your computer and to respond accordingly, that would enhance your learning experience. After the webinar, an evaluation form will be emailed to you, and or it will pop up after you close the webinar on the pop-up screen. This is required for everyone who is participating today. You do not need to complete both evaluation forms. You just need to do one. So you could either complete the one that's emailed to you. I think there will be a link that is emailed to you, or you can complete the survey that is the evaluation form that pops up after the webinar. There will also be a post-test with 10 true or false questions that is required for anyone who is requesting for CEUs or continuing education units. An e-certificate will be emailed out to everyone after you've completed both steps or one or both steps after 3 to 5 business days. If you have any questions regarding this process, you can email me, and my email is listed there. Here is the outline for what we plan to discuss today. We'll be doing a very brief overview of the legal and financial consequences of problem gambling. And then we'll go into, excuse me, we'll go into strategies and tips for negotiating with creditors such as casinos directly, loan sharks, bookies, etc. And then my colleague Anthony Chan, who has conducted a lot of research for us, will be talking about problem gambling in the divorce court context, talking about division of assets. In addition, he'll be also talking about problem gambling in the family court context in terms of child custody, issues like that. Then I'll return to talk about some financial actions and tips and suggestions for affected individuals or family members and loved ones of problem gamblers, steps that they can take to protect their own financial well-being. If we have time, we'll also end with some case vignettes to have you exercise and brainstorm and apply some of what you've learned to some cases. And then we'll end with resources. You'll also see that in the material section, there is a resource list, a Word document with resources that we've compiled, and that will be a good resource for you to refer to after the webinar as well. And I'm about to begin the main content, so I just wanted to make a final announcement that if anyone has issues with audio or problems hearing me, please use the chat box to let me know. Otherwise, I would just go on and on talking without knowing. Thank you. Okay. So let's begin by talking real brief about some of the consequences of problem gambling and how it relates to the financial and legal issues that we're going to talk about today. It's obvious that one of the main issues for problem gamblers coming to seek help is their excessive amount of debt. In fact, when we look at our NICO's hotline that serves the Asian and primarily the Chinese community, the 1888 number, the number one reason cited by our callers for calling the hotline is their overwhelming debt. And this is one of the major reasons that get people to the doors for treatment as well. So let's do a quick poll at this time, a quick true or false question. Is this true or false? Female problem gamblers on average owe less gambling debt than their male counterparts. So I'm going to go ahead and open up this poll so that you all can respond on your computers. So again, true or false? Female problem gamblers on average owe less gambling debt than their male counterparts. Great. All right, so let me go ahead and show the response. It seems like the majority of us feel like it's false. 78% versus 22% for true. Let me go ahead and close that and reveal the answer. This is actually, in fact, true. In the US, on average, a male problem gambler owes somewhere between $55,000 to $90,000 at the time that they are presenting for treatment. This compared to the average for female problem gamblers seeking help at about $15,000 in debt. However, there are a couple of caveats as well. It seems to be that even though on average the dollar amount may be less, that female problem gamblers may actually spend a greater percentage of their net worth on gambling. It was found in a survey that female problem gamblers on average lose about 80% of their total net worth. This is income plus assets minus debt or minus liabilities, that they actually spend a large percent or significant percentage of their net worth. It's not always about how much you could, it's not always about how much you lose, but how much you could afford to lose. This fact, coupled with the fact that most female problem gamblers also start gambling at a later age, generally on average 45 or older, makes it more difficult for female problem gamblers to recoup losses. So definitely there are unique issues for female problem gamblers in terms of debt. In addition to debt related to that, obviously a lot of problem gamblers experience limited cash flow, difficulty holding on to jobs, losing their home private businesses. It's estimated that up to 90% of problem gamblers would actually resort to taking out cash advances on their credit cards in order to finance their gambling. And you can see how that can get them into a lot of financial problems. And up to 20%, 1 in 5 problem gamblers will actually eventually resort to filing for bankruptcy because of their gambling losses. So let's talk about crime. We'll do another poll here. True or false? Most crimes perpetrated by problem gamblers are in fact violent crimes in nature. So true or false? Most crimes perpetrated by problem gamblers are violent crimes in nature. I'll give you guys a couple more moments. Okay, so it looks like everyone has voted and it's pretty unanimous. 100% says false, and you are indeed correct. In fact, most crimes perpetrated by problem gamblers are more white-collar in nature, things like fraud, embezzlement. A lot of times we see the stealing starts with family members, loved ones first, and may expand eventually to workplace, embezzlement, misuse of personal information to open up credit card accounts and things like that. This is not to say, of course, that violent crimes does not occur in the context of problem gambling. When individuals borrow from loan sharks and are involved in illegal activities, oftentimes when desperation drives behavior, other kinds of things like armed robbery and things like that can occur, but they occur at less frequency compared to the more white-collar sorts of crimes. So obviously, in addition to criminal activities, there may be difficulties for people keeping onto their properties. There's a lot of interactions with collection agencies and collectors, things like that. Credit ratings, credit scores suffer drastically for problem gamblers. We've also seen people overnight lose their entire college trust funds for their children, their retirements, life savings, and so forth. In the family, we also see a lot of family disturbance, things like high rates of divorce, family stress, and also high rates of domestic violence. So one final question. What is the #1 cause for broken families among problem gamblers? Is it divorce, separation, or is it suicide, or is it arrest or incarceration? So I'll go ahead and launch that poll as well. What is the #1 cause of broken families among problem gamblers? Okay, I think I'll go ahead and close the poll. And it looks like the majority of us believe that it should be, or it might be divorce and separation. And I'll go ahead and talk about that a little bit. And most of you, again, are correct. In terms of divorce and separation, when we've done research into looking at the rates among different types of gamblers, including non-gamblers, it was found that problem and pathological gamblers, or those who suffer from gambling disorder, experience somewhere between 40 to more than 50% rate of divorce. So more than half of problem and pathological gamblers, up to more than half, can actually experience divorce and separation because of the increased family stress. This compared to just a bit less than 1 in 5 among non-gamblers and about 30% among at-risk gamblers, so about less than 1 in 3. So divorce, separation definitely is one of the #1 causes for problem gamblers, broken families. It's found that actually, in fact, children of problem gamblers are a lot more likely to grow up in broken households and chaotic households, not unlike children of alcoholics. And one of the major reasons is divorce. But the other two factors also play a big part. Suicide. Problem gambler as a group has one of the highest known rates of suicide, between 15% up to 24%. So close to a quarter of problem gamblers would actually attempt suicide sometime in their careers as gamblers. In terms of arrest and incarceration, between 20 to 30% of problem gamblers would face arrest or incarceration sometime in their careers as gamblers as well. So all these factors definitely play a role. So why are these factors relevant to us, as most of us are mental health providers or educators? For the clients that we're working with, obviously, they bring with them a host of issues. Not only are we working with them, not only is it important for us to work with them on their mental health issues, on their recovery, on their ability to deal with urges and cravings, that additional stressors, such as getting calls from creditors, such as loan sharks coming after them, such as the mounting debt, can add to those stresses and can actually become a contributing factor for relapse. And so problem gamblers need to concurrently address their financial issues to stabilize their situation in order for their mental health to get better. So hopefully some of these tips and strategies will be helpful for you in your clinical setting. It's not that all of you as case managers, therapists, and educators, not that you should become financial experts, not that you should go out and get a law degree, although you can. And, we need to be careful of our boundaries as well. To what extent are we able to advise clients on financial and legal issues? We don't want to overstep our bounds, but it is helpful for us as providers or social service providers to know what are some of the options out there, what are some of the resources out there, and what kinds of protections do our clients have under the law so that we're better equipped to help our clients access those financial and legal resources. Okay, so let's first talk about what are some tips and strategies for clients to negotiate with creditors. These are information that I have taken from a book written by Dr. Nancy Petrie, who is a renowned researcher on problem gambling, and she has written a book entitled Pathological Gambling, Etiology, Comorbidity, and Treatment. And this is one of the sections in the appendices section focused on tips for negotiating with creditors. Okay. So for many of us, we might actually know that our clients, gamble frequently in casinos, and many of them actually can end up owing money directly to casinos through opening up lines of credit and things like that. And most casinos actually have their own collection department that you can work through to resolve issues related to debt. Many of these departments actually also have a person who is tasked with the role of negotiating with recovering problem gamblers. So if you know that a client may owe money directly to a casino, it might be a good idea to work with them, to empower them to contact the casino as soon as possible and talk with the collections department. Generally, they're able to contact the casino's main number and ask for either the collections or the credit department and to identify the person they should speak with. It's good to prepare your clients beforehand to know what to say As with any creditors, casinos want to know what their intention is to pay. Clients should let them know that they fully intend to pay them. Working with the casino's collections department may actually be preferable. Generally, they may be easier to work with and more reasonable than if they were to hire a third-party collection agency to go after your client. It may be also helpful for your client to tell the casino that they are receiving help for gambling problems, to let them know what steps they have taken to stop gambling. For example, attending GA, seeing you as a therapist on a weekly basis. It may also be helpful to talk with your clients about considering signing up for self-exclusion. And we'll talk a little bit more about self-exclusion in the next slide. Signing the agreement will show the casino that they are serious and committed to addressing their debt issues. And again, remember, all the casinos want you to do is to pay them what you owe. And most of the time, they're just happy that your client has called to negotiate. A few notes on self-exclusion. In California, we have different levels of self-exclusion. You can request for self-restriction, which can be specific to a type of game or a specific establishment or some other forms. For example, if your client's primary problem is with 2 local card clubs that he or she lives close by, they can actually ask to be specifically restricted to those card rooms. And then if they're on vacation with their family, they can actually visit other establishments and that sorts of thing. If their primary problem is with Pai-Gow poker, they can ask to be specifically excluded or restricted to that game where they can participate in other games as well. They can also restrict themselves from being able to open up lines of credit at the casino or card room. They can also, for example, request to be restricted from the primary gaming area, but still be able to come on the premise to frequent the restaurants or the shops. On the other hand, self-exclusion is the most severe form. It will generally ban you from the premise altogether, sometimes including the parking lot of the establishment. There's currently a statewide program for all the licensed card clubs and card rooms in the state. So you can actually sign up one form to ban yourself from the entire list of licensed card rooms in California. Currently, tribal casinos do not have a statewide system. Tribal casinos in California, they are sovereign nations. And so policies and rules may be different in each casino. Most tribal casinos do offer self-exclusion, but again, how they enforce it and implement it may be very different. Currently in California, they're talking about either having some kind of statewide or, if not, some kind of regional tribal agreements. Some of the tribes that are close by to each other may be able to create some intertribal agreements so that, for example, all tribal casinos in San Diego can have a standard self-exclusion system so that clients can sign up one form and be banned from all of the local tribal casinos. And they can share information about those who are on the banned list. But so far that hasn't gone into effect yet. Some casinos actually also offer a third-party exclusion where a family member, such as a parent, a spouse, a child, can request for their gambling loved one to be banned. Not all casinos offer this. The best way to find out is to call the casino and find out if this is possible. Generally, the requirements for third-party exclusion is very stringent. The client, if it's an affected individual, will have to show that the family is experiencing a severe financial hardship as a direct result of the gambler's gambling. So some documentation and some evidence will need to be likely need to be provided. but can be a good resource. A couple of other kinds of exclusions that you may or may not know about. You can actually look into this website. GCA is Global Cash Advance, I think. Global Cash Access or Advance. They're a company that's used by over 1,000 gambling establishments throughout the world for cash access services. So they provide ATM service, cash kiosks, and other kinds of cash booth services. If you sign up for their responsible gambling exclusion program, you can actually ban yourself from accessing cash at the over 1,000 locations in the world that uses GCA as their cash access services. According to their website, this actually represents the majority of the world's gambling establishments. So of course, if your client goes to a casino or gambling establishment that uses other provider to provide cash, then that wouldn't work. But if they sign up for this program, they wouldn't be able to withdraw money through their credit cards, their ATM, bank cards, and other methods to withdraw money. The exclusion is good for a minimum of 1 year. You have to sign up at least for 1 year, and it's optional renewal after that. So you can look at the website for more info. There's also a software that allows you to block access to internet gambling. So if you have clients who has problems related to internet or online gambling, GameBlock could be a potential resource. I believe this was a software that was invented by a recovering problem gambler. And so, again, these links are in our Word document resource list. You can access those websites for further info. And again, if there are any questions or comments throughout as we go, you can feel free to put them in the chat box and I'll see them immediately. Real quick, let's talk about loan sharks. Excuse me. So what is a loan shark? Essentially, an unlicensed money lender that works outside the law. Typically, people who borrow from loan sharks pay a lot of interest. We've heard of clients who have 100% interest that's compounded daily, which means it doubles every day you don't pay. Clients who fall back or aren't able to pay often could get harassed. Sometimes they could even get pressured into borrowing more money. Nikos has worked with the State Bureau of Gaming Control, and they've let us know that in recent years there's been some trends, some emerging trends of a lot of loan shark operations that have come out of China or have a base of operations in China. And a lot of these loan sharks will work with a large team of people who disguise themselves as regular gamblers. They socialize and chat with fellow gamblers. And if they see that they are on a losing streak, would actually offer them money. At which point a client may actually take on the loan thinking it was a nice fellow gambler who is lending them money, which in fact they actually borrow money from a loan shark and end up connected to that kind of operation. So you may be hearing things like that from clients as well. Always advise clients to beware of strangers that just come up to them, or people they feel like they've talked to, in casinos offering to lend them money. Ways to negotiate with loan sharks and bookies. So again, loan sharks and bookies, although illegal and operating outside the law, are creditors too. And all they really want is for your client to pay them what they owe. And they usually will accept long-term payments because obviously the longer you take to pay, the more interest you're paying in the long run. There are those who are called trusted servants. In GA, often these are the sponsors. These are people who have a lot of experience with recovery. They also have a lot of experience dealing with loan sharks and bookies and other creditors. They can be a good source for advice. Before your client negotiates with a bookie and loan shark, it's helpful for you to plan with them on what they should say. Clients should let them know that they fully intend to pay, but just can't pay in full at this time. It's also helpful to let them know that they have a gambling problem, they recognize it, and the steps that they're taking towards resolving that problem to reduce or stop gambling. To also let them know in what ways they're working on the payment plan, whether they're taking on additional jobs, what other sources of income they're looking into. It may be not uncommon to hear from clients that they get intimidations or threats from loan sharks. And generally, these threats are supposed to increase your client's resolve to address the financial debt. The client should never ignore, avoid, or insult the bookie. Be humbled but dignified when speaking with the loan sharks, which obviously can be difficult. But these are good things to work to go over with your clients before they actually do so. And again, a lot of clients may have fears or anxieties dealing with loan sharks because of a lot of stories in media and things out there that it's helpful to assuage some of those fears, to let them know that bookies and loan sharks are business people too. And they know that if they break your arm, break your leg, you can't work, that's money that they're not going to be able to pay the loan sharks and the bookies. And also if they rough up your client, they get arrested, that's time away from their business. So hurting your client or their family really puts their business at risk. So, however, always take threats seriously. If threats continue or actual harm is done, clients should definitely contact local authorities immediately, and also at the same time get advice from GA members. As always, if clients believe that there is imminent threat, that they are at imminent risk for physical harm, they should contact 911 local authorities. However, for clients who want to report possible loan shark operations and or for therapists who know about larger loan shark rings and operations, you can also contact the Bureau of Gambling Control. And I have those contact resources in the resource list that I mentioned earlier. Let's move on to talk about creditors. So clients may also get calls from creditors, collection agencies, and these calls can create an additional layer of stress for your clients. A lot of times, getting these calls can actually pose a risk as they can trigger an urge or craving to return to gambling for clients, and they could be a threat to relapse. So some guidelines for you to know and that you're able to educate your clients on how the law protects them from collection agencies to prevent harassment. These are the parameters that collectors have to work within. For example, creditors are not allowed to call your clients earlier than 8 a.m. or later than 9 p.m. If your client does not want the collection agencies to contact them at work, they have the right to tell them so. If the creditors are provided oral or written notification, at that point, they're not allowed to contact your client at work, especially if your client work site prohibits such calls. Also, creditors in general are not allowed to talk to a third party about the client or their debt. There are some exceptions. For example, collection agencies are allowed to call a third party only to get the location information about your client. If they aren't able to locate your client, they need to know where they are. But even when they call a third party, there are rules governing what they could and cannot say too. For example, collection agencies are required to give the third party their name, but not allowed to give the name of their collection agency, so as not to reveal the fact that the call is coming from a collection agency. If your client wants the creditors and collection agencies to stop contacting them altogether, the best way for them to do so is to do it in writing. So they should write a letter requesting formally that the collection agency stop contacting them. They should make a copy of the letter and send the original letter by certified mail and request for return receipt. It would be important to document the time and the date when the collection agency has actually received the letter. From that point on, they're not allowed to contact your client, with the exception of 2 situations. They may contact your client again to tell them that there will be no further contact, or to let them know that they're going to take specific action, such as filing a lawsuit against your client to recover their money. A few other notes on collectors. Again, the law says that they're not allowed to harass you. However, the law doesn't really specify what constitutes as harassment. So if clients do feel like they're being treated unfairly or too aggressively, they should definitely document everything. What kinds of things should they document? Dates, times of when these conversations occur, and the details of what occurred during those conversations. And then they should pass those information on to the state's banking department or an attorney if they have one. Another way for clients to stop all communications from collection agencies is also to hire an attorney if they are able to. Once the creditor is notified that your client has a legal representative, all correspondence must go through that attorney and not to the client directly. So these are some of the protections for clients that may be helpful for them to know if they are dealing with those issues. Again, some general tips: negotiating with creditors, ask to speak to supervisor if their initial request is denied, never agree to pay more than you can afford. You never want to get into a situation where you make an agreement with creditors or collection agency and you fail to pay or to keep up your end of the bargain, and that could get you into more trouble. You should find out during negotiations what the creditor is willing to accept. Most of the time, the creditors know, if they know that they're not going to get everything, they're happy just to recover a percentage of what's owed to them. And this could be anywhere from half up to 70% of what is actually owed. You should prepare your clients mentally as well, that this is not something that will happen overnight. Negotiations could take time and may require multiple rounds that could be days or weeks. Again, clients should make sure that everything they agree with is in writing, signed, and dated by both parties. I also have a web link here that's also listed in the resource list for the Office of the Attorney General's Office that will have more guidelines about consumer protection for collection and collection agencies. I don't see any questions, so I'm going to move on. Working with credit card companies. There are also ways to freeze interest rates. The best way is for clients to either themselves contact the credit card companies, or they can work through nonprofit credit consumer counseling services, or services that can consolidate their credit card debts and things like that. A lot of times the credit card companies will be willing to freeze interest rates in the interim while they're trying to pay off the balance so that they're not incurring more debt in the meantime. And the best way to do so is to either call a company directly or to do so in writing. Oops. So before we do that, I'll just share a little bit more about the credit card interest rates. We've listed resources for nonprofit consumer credit counseling services in the handout, and so you can refer to that for more info. All right, Which of the following statement about bankruptcy is true? So this is another poll that we'll do real quick. I'll read it out loud. A trustee can be designated to liquidate your assets to pay your debt. B, you can keep your property but make monthly payments in 3 to 5 years to pay some or all of your debt. C, bankruptcy cannot wipe out some debts such as child spousal support or tax-related debts. Or D, any of the above. So I'll go ahead and launch the poll. I know that when there's an all of the above, usually that's typically the right answer, so probably might be a giveaway. So I'll go ahead and close the poll at this time. Sorry if you haven't voted yet. So in fact, depending on what type of bankruptcy that you fall within, that you're eligible for, any of these could be true. There may be some type of bankruptcy where they actually have a trustee that's designated to take some of your property and to sell them to pay off your debt. There's other types of bankruptcy where you get to keep your property, but you must make monthly payments within 3 to 5 years to pay off some or even all of your debt. And there are certain types of debt that is not dischargeable under bankruptcy. So a few notes on bankruptcy and for your clients. It should be noted that, when we work with people who have addictive disorders, we have to help them and give them a reality check of what bankruptcy can do and what it cannot do for them. Bankruptcy should be seen as a last resort. It should not be viewed as a quick fix to their financial problems because, again, the court will look at the whole situation and determine whether debts are dischargeable or not. In some situations, the gambler may still have to pay some of their debt, and there are a lot of problems associated with filing for bankruptcy too. Bankruptcy stays in your credit report for 10 years. And that can create a lot of problems for clients in recovering financially. They will likely have a lot of difficulties getting a mortgage loan, getting loans for cars, maybe even getting a job. So there's a lot of financial implications for filing for bankruptcy, and it's difficult. Recovery can take long. So with that said, for some clients, bankruptcy may be the only option if the debt is so insurmountable that even with taking on additional jobs and sound financial management, they still aren't able to pay off the debt. Bankruptcy could be the only solution to discharge some of the debt. What the bankruptcy court will look at really is your state of mind at the time that your gambling debt is incurred. They would be interested to know, for example, did you intend to pay or did you just rack up a lot of debt right before you filed for bankruptcy and you intend to use bankruptcy court to get rid of all that debt? So was the debt incurred in good faith or bad faith? How will they look at that? For example, let's say a client, signed for a marker at a casino in exchange for chips, claiming that they have the funds to cover the chips, when in fact they did not. A court can look at that information and say, you borrowed the money deceptively and that you never intended to pay back and that you're using bankruptcy law to try to discharge the debt. And in that case, they may not discharge those debt. You may still be required to pay off those debts. So let's take that same situation and say, and I'm sorry, I forgot to hide the poll. So now you can see the slide. So now take the same situation. The client, after the fact, recognize that, wow, I'm gambling has gone over my head. I'm in a lot of trouble. I need to stop gambling. So they stop gambling altogether. They get help and they start to pay off some of that debt. and then they realize they still aren't able to pay off all the debt that they incurred, and they file for bankruptcy. The court in that situation may say, well, the client has made good progress, they seem like they have taken steps to stop gambling, and that some or all of this gambling debt may be dischargeable in bankruptcy law. So again, some of the warning signs for bankruptcy court, some red flags would be timing. If your client is filing bankruptcy really close to the time that debt was incurred, for example, within 2 to 3 months, that could be a red flag for bankruptcy court. They can assume that you never intended to pay in the first place. So some of the things to consider if clients are considering bankruptcy is that timing. Is this too soon after debt is incurred? You have to make a longer effort to try to pay off some of that debt. You have to take steps towards stopping gambling and to get treatment and get help, attend GA, and so forth. And again, bankruptcy law is already so complicated, and when it has to do with gambling debt, it becomes even more complex. So clients definitely need to consult a licensed attorney before they make any decisions about filing for bankruptcy. So hopefully this gives you some ideas about what bankruptcy courts might look at and what some of their considerations might be. Okay. Again, all of these things, working with creditors, you have to prepare your clients, because meeting with loan sharks, bookies, talking with creditors on the phone, dealing with collection agencies, all could trigger urges to gamble. So making a plan with your clients about how to talk with someone they trust, either a non-gambling friend or their sponsors at GA or you as a therapist immediately after, can be helpful. And to work with your clients on identifying the emotions, the feelings, the thoughts that go with their urges to gamble can be good methods for relapse prevention. So at this point, I would like to ask my colleague Anthony to take over and talk a little bit about some court cases related to division of assets and child custody. So I'm going to have to switch presenter over to Anthony, so please be patient with us and give me one moment while I do that. And Anthony, at this time, you are the presenter. I'm not sure how to share the slides, however. Give me 1 second. Let me try something different. Anthony, I'm going to give you control of the slides, and I will unmute your audio as well. Give me 1 second. Okay. Anthony, are you there?
Yeah, yes I am.
Okay, so I believe you have control of my slides now, and you can take over.
Okay. Let me see. There's a show screen. There it is. All right. Good morning, everybody. Thank you for joining us today for the webinar. I'm going to be giving a summary of some of the previous outcomes of cases that Michael and I researched, and hopefully answer some of the questions that are posted on this PowerPoint, which are: what are some of the previous outcomes of cases involving problem gamblers, and what possible solutions can be learned from those cases? And also, how does family law intersect with gambling debts and winnings in these cases? These are lessons and summaries that we took from other people's legal interpretations. Please remember that this is not our legal interpretation of the outcomes. Okay. Oh, oops. So in the first case, Lou versus Sai, the context of the case was that the wife gambled a large amount of community funds without the consent of her husband. She gambled over $370,000 of community funds away, but she also actually reported about $200,000 of winnings to the IRS. However, those winnings weren't shared with the husband, and what had happened was that the court actually ruled that because the community funds were used for non-community interests and also without the consent of the other spouse, and because it was not shared, it was actually a breach of fiduciary duty, and her husband, Leo, was awarded 50% of the community funds that were gambled away and also 50% of the gambling winnings. Oops, let's go back here. So what the court justified was since community funds were not used for community interests, the funds that the wife, Angela, won is actually entitled, or 50% of it is actually entitled to her husband, even though he didn't win it, because the character of the funds follows the origin, which was the community funds. And in the second case we have here, in the remarriage of Cairo, what happened was the wife was able to prove that the debt incurred during their marriage on credit cards was due to the husband's gambling and not hers. Usually when debt is incurred during marriage, it's split in between the parties. But there's a family code 2625 that gives the court the power to assign debt incurred during marriage to one of the spouse if the debt was not incurred for the benefit of the community. And that allows the court to actually just assign debt to the husband because the wife was able to prove that the debt was incurred solely because of the husband's gambling. And there's family code 2602 that lets the court award an offset against a party's community share if it finds that the amounts used were misappropriated by a wrongdoing spouse. And that's what the court did here in this case. And using family code 2602, the court characterized that the credit cards in the wife's name was a community property, but the credit cards in the husband's was his separate property. And the husband actually incurred the debt on his credit cards. So the debt was just offset against him and not his wife, even though they were married and the debt was incurred during their marriage. Okay, let's go to the next. Yeah, there it is. And the ruling is that the debt was not incurred for the benefit of the community, so therefore the court was able to assign it just to the husband. And in their case, we have here, what happened was the husband took $10,000 of the community assets or the savings, and he won $22,000 in a casino. Then he bought a Ferrari for $32,000, but he claimed that $22,000 of that Ferrari was actually his separate property because he won it. However, the court ruled that because he used community funds to win the gambling money, the winnings were also considered community property. So they rejected his argument and say that half of the winnings were actually attributed to his wife as well, even though she didn't technically win it. And what's interesting here is that the court actually also stated that gambling is mainly a game of chance where the skill component is very small. So that's a second rationale that they use. And so the implications from some of the outcomes that we saw was that if, again, this is not our legal interpretation, this is more of a summary of the findings and the rationale that the court uses to make the ruling, is that gambling takes place without the knowledge or consent of the other spouse can actually be a breach of fiduciary duty, and the gambling debt can actually be assigned just to one party, even if it's incurred during the marriage, if the community funds and gambling was not for the benefit of the family. Also, the gambling earnings can be considered community property assets and divided equally, even if one of the spouse's members did not gamble. And this is the evidence of spousal gambling that's in the site provided from Judge Cheryl Moss, whom I was able to get in contact with, and she's a family court judge in Nevada. And these are some of the examples of things that she said the court usually looks for as evidence of spousal gambling. And that can include credit card statements showing frequent cash advances, frequent withdrawals of bank statements and ATMs. For ATM withdrawals, Judge Moss said that they really look at the location, amount, and frequency of the withdrawals. And the judge can actually also subpoena a casino to look at their gambling records and behaviors, although that's a bit rare. But then there's also receipts of payday loans, pawn shop tickets, and also testimonies from other family members as well. Tend to all contribute as evidence to build up the case against the gambling spouse. Now I will talk about custody, some custody insights, and also what happens with divorce and separation. This is also from my interview with Judge Moss, and she actually told me that since most judges are not trained to spot problem gamblers, they'll only investigate the possibility of a problem gambler if one spouse accuses the other. And once the problem gambler is identified, what she said the judge should do is refer them to treatment, and this is during as the trial is going on, and have also the treating provider submit progress reports so then they can monitor whether the problem gambler is a risk to himself or to children, especially if they're going to fight for custody during the trial. And what was really interesting that she told me was that the gambling spouse can still actually, and they sometimes do end up with joint or primary custody. This happens usually if the other spouse fails to respond to the complaint for divorce, or they just have a lack of resources. So the gambling spouse has more resources. They can, even with the identification of the gambling problem, they can still win custody and primary custody as well. Although she says the judge can still require the parent to be assessed if the safety of the children is in question. And these are some of the common custody issues that she brought up, which can determine physical custody, supervised visits. The major concerns that usually come up are it's abandonment and neglect. In the red, these are some of the examples of cases of abandonment or neglect that's come up. And so, for example, you can see San Jose woman arrested after deputy finds her children inside a car at the casino. San Ramon couple charged in home alone case. Kids left in car while mom allegedly plays slots. And in this case, if both parents are identified as problem gamblers, what happens is there could be a default custody order or a case where the judge takes the child away and places them in a temporary home. She says that cases like that do tend to get complicated because it involves a variety of different factors, but these are just some of the overviews of what happens during child custody cases. And a family court judge can also make temporary court orders. She's told me, I think she's done this before as well, that includes treatment for a parent's problem gambling issues. And then that can also allow, if the problem gambling parent shows that they want to get better and get treated in order to gain some custody rights or at least some visitation rights, the judge can do this and have orders to monitor the parent's recovery. So then, as long as the patient or parent demonstrates compliance with the treatment, support groups, medication, gambling anonymous meetings, and then they report and exclude themselves to casinos, the judge can actually lift restrictions on supervision, possibly increase the timeshare, because Judge Moss says that the court really wants to invest in the treatment of the problem gambling issue rather than punishment of it. All right, and now Michael will talk about the financial actions for tips for loved ones.
Great, thank you so much, Anthony. I did want to especially thank Anthony because he has done a lot of the research for us to interview Judge Cheryl Moss from Nevada and to talk with a lot of other key informants, attorneys, therapists about different issues that we had presented today. And he did such a great job presenting our materials today. Thank you so much, Anthony. Okay. So let's see. So this is the last section before we wrap up. These are some tips and suggestions now of financial actions that loved ones, affected individuals of problem gamblers can take. So some ways for the family members to restrict the gambler's access to money, obviously, it would be important. So the non-gambler, first and foremost, should do an accounting to make sure that they are not, or that they are removed from all joint accounts, including, excuse me, please give me 1 second. Okay. Including joint credit cards, bank accounts, and open up new accounts that is in their name only. They should certainly not share their PIN numbers and sensitive information with the gambler. Another thing they can set up is what's called a debit block. So this is something that you can do directly with banking institutions where only transactions are authorized by you can go through. So for example, if you set something up on your bank account and you let the bank know that only allow debits of my account from my mortgage title company, my PG&E electric bill, so that anything that's not authorized or any attempts to withdraw money will be denied. So most banking institutions will have will offer something like this. Make sure that your client does not co-sign any loans or other financial obligations with the gambler, obviously. In addition to access to money, there are some ways to access the gambler's access to borrow money as well. So family members can help by being more vigilant about shredding credit card offers, making sure that all these things we get that we call junk mail, a lot of convenience checks that your current credit card companies may provide you, cash advances, things like that, are shredded and tossed away, so that they don't also serve as a trigger for the gambler as well. You can also put a freeze on the non-gambler's credit report. So why this is important, because it will limit new credit card offers and also give you alerts if someone tries to open up new accounts with your information and social security number. We've had situations like that where clients have taken up 4 or 5 credit cards in their spouse's name and social security number and max them all out. The non-gambler should protect their own finances by putting a freeze on their own report so that they're alerted of any misuse or identity fraud. You can also ask creditors to stop granting credit on both the gamblers and the non-gamblers accounts. There's also ways to opt out direct mail. So if you're tired of shredding all those different documents, this can be done by anyone. You may have already heard about this. You can go to websites like optoutprescreen.com. And again, these resources are listed in your resource list that I have uploaded. Or you can call a toll-free number and put your address on the do not mail list, and you will not receive those pre-screened credit card offers and things like that. You can also put all your landlines and mobile phones on the National Do Not Call Registry. This will limit some of the solicitation calls to, again, offer those different kinds of credit and other services. Some ways to prevent access to family assets. Family members can consider opening a safe deposit box that's not accessible by the gambler to keep valuables. At one point, my stepfather, who was a problem gambler, got so desperate for cash, he actually stole my mom's jewelry, took it to the pawn shop, thinking he was just borrowing the jewelry, and that when he won, he would buy the jewelry back, which ultimately never happened, obviously. For family members who want to protect their family heirlooms, valuables, should consider doing something like this. It's also important to ask family members and friends to let them in on the issue so that they can all support the gambler and the family members. This obviously can be difficult for a lot of the immigrant populations that we work with. I had a colleague whose mom was the problem gambler, and it turned out that she was going behind everyone's back and asking different family members for personal loans. And so unbeknownst to each other, everyone was giving her money at different times in different amounts. So it can be difficult because obviously for some groups that we work with, airing dirty laundry is a big taboo, and that, these are issues that they don't want to talk about outside of the immediately family. But it can be a powerful tool if family members can be let in on the issue so that they know not to enable the gambler's behavior. Family members should also consider things like retitling the children's financial accounts to prevent access and misuse by the gambler. Other things, these are things that definitely family members of problem gamblers should talk to an attorney, financial advisor, and other experts about how to protect and safeguard their assets like retirement plans, life insurance, inheritances, and things like that. And what are some ways to monitor the gambler's behaviors? So these are things that definitely would be important to get the gambler to be on board with and to help them understand that these aren't things that we're doing because there's that they're not trustworthy or that there's that they're bad people, but that these are things that could be beneficial and protection for them as well. How do you establish email or text alerts from all financial institutions? Many of them you can easily do online to sign up for alerts that anytime any transaction happens, such as withdrawals, deposits, or wire transfers, or anything like that, you would get alerted. So that if there's a transaction that you yourself have not authorized or initiated, that you would know. And you could do so with credit reporting agencies too, likewise. You can also enable the GPS on your gambler's phone. Most smartphones come with GPS, and it's by default enabled. For example, on iPhones, you can use the Find My iPhone app, and to a high degree of proximity accuracy to know where the gambler is at various points. This way you can know if the gambler is actually at a racetrack, casino, and so forth. being able to prove where the gambler is at different points can also be helpful, as Anthony mentioned, being able to document some of the behaviors and activities of the gambler at various points of the relationship. The family members may also want to consider some longer-term solutions to protect their own assets. And there will be a lot of, these are more drastic steps that could have more implications, and we'll talk about some of the implications later in the next slide as well. The non-gambler should consider taking charge of all household finances, including paying all the household bills. So one of the things that we suggest too is that if the non-gambler is able to pay as many of the bills online electronically as possible. That way, the gambler and you don't get a physical bill in the mail and in your hand. That could become a trigger where the gambler may try to persuade the non-gambler to put off paying the bill so that they could have access to more cash for gambling and things like that. But certainly, the non-gambler should be in charge of making sure all household bills are paid, at least initially, while the gambler is in recovery. Again, limiting gamblers' access to cash through the methods that we had discussed. If it's possible and the gambler is still working, ask the gambler to reroute their check deposits so that it's deposited electronically in an account that the non-gambler controls. If the gambler is receiving physical checks and their workplace does not allow deposits electronically, work with the gambler if possible to ask them to turn over the checks physically to the non-gambler as soon as they get it. Or if the gambler gives consent, let the non-gambling spouse or partner to come to the workplace and physically pick up the check. It can be a trigger for gamblers to physically hold the check in their hand, to want to go and cash it out at a check cashing service and to use it to gamble. So any opportunities to cut out those triggers and stimuli can be helpful for the gambler's recovery. In the long run, the non-gambler might also want to consider shifting ownership of property such as homes, cars, other vehicles to their name only. And again, there are implications for this and we'll talk more about. It's important to know too that if this is happening between two married spouses, there should be no tax implications. However, if you're transferring property to, let's say, a child or to a relative or to a friend, there may be taxes that have to be paid. In some situations, if both parties, both married couples or both partners are problem gamblers, they may considering transferring control of assets to a third party, to a trusted relative, to an adult child. And again, this is an extreme measure and should only be undertaken after they have gotten advice from an attorney or a tax expert. Sometimes there may be a situation where the adult child is the problem gambler. So parents may decide to put their money into a trust where a trustee will be designated as a person to parcel out payments to the adult child so that they don't spend all their inheritance at once the parents pass away. And the trustee, again, could be someone that a bank designates an attorney or financial planner, and in some situations could be a trusted individual that the parents could designate as well. So, as always, we need to keep in mind, too, to balance all the protections for the different parties involved. For therapists, we need to keep in mind who is our client. Is your client the gambler? Is your client the affected individual? Is your client the family system if you're providing family therapy? And how do we make sure that we keep in mind everyone's best interest? For example, how do we protect the problem gambler's assets if we're transferring property over to other people? If we are putting all the homes, properties, and cars under the non-gambling spouse name only, what would happen to the gambler if the other spouse decides to get a divorce? Who has claims to what property? What claims does the gambler have? If we're transferring all the control of money to the non-gambler, what's to stop the non-gambler or the relative to spend all of the gambler's money? So in situations where there is someone passing away or there's a divorce, tools like postnuptials and wills will be really important to protect to give protection to the problem gambler as well. A postnuptial is an agreement that you sign after two people have been married, and it can describe how property will be split up, including property that is owned solely by one spouse in the event of divorce. An agreement not only is helpful to protect, it can also help reduce some of the anxieties and the fears that a gambler may have about turning over control. Sometimes that could be a very stressful thing, losing control of all your finances and not knowing if your spouse leaves you, what would happen to all your assets. So this can actually provide them with some protection. You should keep in mind, however, that once divorce process begins, the divorce court will also have a say above and beyond the postnuptial of how property is divided. So it's not an end-all be-all, but definitely it can be helpful. Again, a will can be helpful too. If a gambler has turned over all the assets to the non-gambler and all the finances, they should designate where the property should go after their death, whether it should go back to the gambler or to someone else that they designate for the benefit of the gambler and the gambler's family. There's a resource book that we've listed in the resource list that's put out by the National Empowerment for Financial Education and the National Council on Problem Gambling that has a lot more details, that talks about a lot more specific scenarios and items. So I think that would be a helpful resource if you are interested to know more. Some challenges for us working with the people that we are familiar with. A lot of the immigrant population that we work with are service workers who work in restaurants and places like that pay in cash, that pay under the table at times. So cash flow, there's no pay stubs. So cash flow may not be easily tracked. Information may not be easily discerned. So those are issues that we may want to think about. How do we overcome that if we work with family members who need to document who is spending what, how much they're making? That could be a challenge. In some situations, when we work with immigrant populations or ethnic minority groups that may have cultural roles for different genders or different age groups, that can create challenges around shifting financial control. Like, what do you mean I can't control my own money? I'm the grandfather of the family. I'm the head of the household. I am the husband, so on and so forth. All those issues could cause frictions and challenges when we are asking them to shift control of finances and other household responsibilities to someone else. As always in these situations, as counselors, as clinicians, as educators, we need to be aware of potential risks for the loved ones. Safety first. We know that domestic violence is highly correlated with problem gambling. We also know that when we ask someone to give up control, that can be a potential dangerous situation for the loved ones. So before our loved ones confront problem gamblers and requests for changes to the financial situation, we also may need to do safety planning with the loved ones to make sure that they're not put in harm's way. How do we mitigate some of those risks? It's possible that if it's possible, involve community leaders, people who are trusted, faith leaders, elders, other members of the extended family who are well trusted, well respected. Their voices you can know will be heard. They not only, when you bring them in, it not only helps to make the process more smooth, that it will also create more support for the gambler and the family as a whole. And you may have other suggestions too, and I'd love to hear it. If you do have any other thoughts and suggestions about working with special populations, please feel free to put so in the chat box. So I think we have a little bit of time. Why don't we take a little bit of a time to do one or two case vignettes before we end? So this will involve you putting some responses in the chat box and in response to the vignette. So let's look at this one. Maria and her husband Salvador began making the hour-long drive to the local casino after it opened. Salvador has a modest income of $3,000 a month, but managed to rack up a debt of $18,000 in less than a year. Maria decided she had to take action to save the family's finances. What are some steps Maria can take to help control the family's finances? So let's take some time, and whenever you're ready, let's put some thoughts in your chat boxes, and we can and then we can discuss a little bit. You can also include, if you have any questions as a therapist, what would you want to know more about? What might you prioritize? What are some of the immediate actions? Okay, so I see a couple of responses. Malcolm mentioned about having a conversation between the two to discuss some of the financial issues and problems. Maria can also take steps by stop going to the casino with her husband as well. Might want to take some steps to limit his access to the family's money from Helen. She can talk to husband about getting counseling, about some of the other resources like GA, self-exclusion forms, change access to finances. Malcolm wants to know, does he accept his financial problems? Does he accept his role in creating the financial problems? And this is quite a large financial problem, right? This is 50% of their annual income. And so it's quite a big debt. Maria should do the FF. What does that mean? Financial? Husband to turn over income to Maria to manage, so that could be a good strategy for the monthly income to come directly to Maria instead. GA has a pressure relief program to come up with plan to pay back debt, which is a great resource to help recovering problem gamblers to do some financial management and to have a financial plan. This is great. You can keep putting up answers, and I'm going to bring up some of my thoughts too that I had come up with, which is not exhaustive by any means, but if possible, you guys mentioned talking about to Salvador about restricting access to cash, maybe signing self-exclusion, rerouting paychecks, start documenting gambling activities and debt for Maria possibly as well. Explore sources of debt. Where is the debt originating? Is it personal loans? Are these monies owed to credit cards? Are these monies owed to casinos, so that we know what some of our next steps might be to reach out to creditors to explore payment options? So you guys came up with a lot of great examples. So why don't we do one more real quick before we end too? I think we still have a little bit of time. Helen also mentioned talk to casino debt department to set up payment options. That would be fantastic option as well. Ron is a 68-year-old retired vet receiving problem gambling treatment from you. He has disclosed that his gambling has gotten so out of control he is considering dipping into he and his wife's life savings. He has also shared that they are struggling with monthly bills and payments, and now his behaviors could put his family in serious financial jeopardy. You cannot convince him to stop gambling. What do you do? Are there things that you might do differently with this case than the previous one? Are there some unique issues, considerations? Family needs to get legal advice, possibly? Okay. Go to the bank and block his ability to withdraw funds. So that will definitely be a good and important step. If Ron is your client, if the wife is willing to be involved, working with the family as a unit to work out ways to block his access to life savings accounts if he's agreeable. Maybe having family sessions. For the sake of time, I'll also bring up some of my thoughts now, and then we can end with resources. And you can keep putting up your responses as well. Some of the other things to think about, because Ron is over 65, there may be issues regarding mandatory reporting that you may want to consider. Is this a situation where there may be financial self-neglect? Self-neglect refers to the fact that an individual who is over 65 or an adult who who is living with a disability may be unable to care for multiple aspects of their lives, either physically or even financially. In fact, self-neglect is one of the most common forms of reports for to adult protective services, even beyond neglect or abuse by others. In this situation, is he unable to care for his own finances? Is this something that you may need to consider reporting or not? Again, restricting access to life savings account, maybe working with a financial planner regarding the monthly bills and payments and other loan repayment options to work with them to outline all the different debts and sources of debt and how they can do that. You will find in your material section that there is a document called Problem Gambling Financial Inventory Worksheet. This is a resource put out by the National Financial Education organization that I had referenced earlier, and it's a whole inventory worksheet of outlining all the different sources of debt and all the sources of income. It could be a great worksheet to adopt for your clinical practice as well. That could be a great tool. So let me end with resources here with the time that we have. Again, the resource list will be a lot more comprehensive, but we've listed some ways to get credit reports, some resources to look up credit counseling, referrals and resources, phone numbers to opt out on unwanted solicited loan credit card offers. We also listed some legal resources that particularly work with the API community and immigrant community, and they could definitely make referrals to additional other communities as well. There are also some family law resources that you could read more up on and to find out more information about. So I want to again express my deep gratitude for spending your Saturday participating in this webinar. This is a lot of information that we've collected. We hope that it was useful. I don't, this is the first time we're presenting information like this. Feel free to let me know either in the chat box or in your evaluation too if you feel like it's too basic or that it's not in-depth enough. We would definitely love to be able to improve upon this and incorporate this information in more of our presentations in the future. And so thank you again. I hope you enjoy the rest of your weekend, and please feel free to do the post-test and evaluation afterwards. Thank you guys so much, and we'll talk soon.